Welcome, everybody. We're so excited to have you join us today for this video that we've put together again in our series to help out personal representatives as they approach their new job handling an estate. And also, we hope it might be helpful for those of you who are considering your estate planning and want to understand what the process is going to be so that you can really do your best job to make sure you've set things up well for everyone. My name is Nicole Rieker, and I am a CPA with JCCS in our Missoula office. I have my colleague with me today as well from our Great Falls office, Lana Kadoshnikov. And our special guest is Jon McCarty from Scott, Tokrud, and McCarty attorneys out of Great Falls. Jon and his firm are experts in estate planning, and so we are so excited to be here today with him to really get his input and perspective on this important piece of the estate planning process. So thank you so much, Jon, and welcome.
Oh, thank you. It's a pleasure to join you, Nicole and Lana.
Well, thank you. Well, we've really enjoyed working with you and your firm, and we know that you do a great job for your clients. And so we're just hoping that you can clarify some of the mysteries of being a personal representative. So maybe just to get us started, you can tell us about what to do when you become a personal representative. What should we be thinking about right away?
Sounds good. I think the starting point would be to say that if I'm to the potential personal representatives, that be comforted in knowing that not all estates end up in litigation. You're not sentencing yourself to taking on, a situation that is uncomfortable in all instances. It's very infrequent, but when it does occur, litigation usually is a product of two things. Someone's upset, and they're upset either because they're upset with the circumstances. They feel that perhaps they were unfairly left out of the will or didn't receive their fair share. And they're questioning whether or not the creator of the will or the trust had the capacity to create that plan or was unduly influenced. And so they're looking to invalidate the estate plan. The other reason that is common is that they're upset with the personal representative and the acts that the personal representative has either done or not done. They've either done something that has caused what they would consider to be a breach of their fiduciary duty. And so that's what we can focus on today is, to eliminate that type of situation.
Excellent.
Now, I think one of the first things that the personal representative needs to be thinking about is, I've just been appointed by the court. The court does appoint the personal representative. What do I need to be thinking about out of the gate, out of the start here? And in my opinion, I think it's very, very simple, is first thinking about you're now handling the estate, the assets of someone else. And so you're a fiduciary, you have a fiduciary duty to protect. And so you want to make sure that you are determining what assets that person has. And if they need to be secured, if the house needs to be secured, make sure it's locked. Maybe this was a single individual who's now the house is unoccupied. Maybe you just want to make sure that it's secure. Maybe it was a place of business. Do we even need to go as far as changing the locks? If it becomes, we're not sure if there were a lot of keys that were out in the neighborhood, friends, or who knows, might that. So that'd be a consideration to do. Of course, we want to locate the decedent's records. We want to know exactly what the plan is. If you don't know already, make sure we've located that, the will, the trust, what might be, so we can carry out the decedent's wishes. We always want to make sure that we're proceeding according to plan. And then also always keep in mind that when we're dealing in situations, we're dealing with folks who have lost a loved one. They could be grieving. A personal representative is someone who's handling the estate. And so we want to make sure that personal representative is always communicating with the folks that are interested in the estate, so they know what's going on, because it might otherwise create an element of distrust that could otherwise be avoided. And when distrust comes into play, then we get back to what I started at the beginning, dissatisfaction with what the personal representative is doing. So always be transparent, always let people know what you're doing. And then I think,
very good point on communication. It's really true in every aspect of our lives, isn't it? The more we can really get on the same page, the better off we end up.
Yeah, I think managing expectations is true in all realms of what we deal with. Particularly true though when you're dealing with an estate in our topic today. Another thing that the personal representative should be considering is, okay, we've secured the property, we know what the plan is. Now I'm ready to look at my duties and what it is that I've got in front of me. And so you're appointed by the court. One of the first things you want to do is you want to give notice, formal notice to everyone that is interested in the estate, who is an heir of the decedent or a devizee, meaning someone who's named in their will, given notice that you've been appointed. Here's how you can get a hold of me. Maybe even deciding to give them a copy of the trust or the will at that point. And then looking at, okay, what do I need to be doing as I'm going down the road? I'll just name some general things. One thing we need to make sure we're doing is, if it's a probate, we're publishing notice to creditors. That's published in a newspaper once a week for 3 weeks in the county where the decedent was domiciled. And what that does is it creates a deadline for others to bring claims against the estate. And that's important because we need to have some closure. We need to have some clarity as we're going forward. And so that publication of notice to creditors from the first date of publication, that creates a deadline of 4 months in which creditors have to make claims against the estate. So we've got some order to the estate going forward. Another thing that the personal representative needs to be doing, and this can be during that 4-month period, we can always be working on the estate, but marshaling the assets, that's called, is determine what are the assets of the decedent, where are they, securing possession of them. Maybe we're liquidating an account, a savings account, bank account, putting it into a new estate account that the personal representative has authority over, and ultimately itemizing and creating an inventory of the estate. Now that inventory is due within 9 months of the appointment, so that's a deadline to keep in consideration as well. As we're going forward, one of the things where we want to keep in mind what we're doing is that as a fiduciary, when I'm handling the assets of the decedent, I need to be creating and presenting to the heirs and devisees a financial accounting of the estate. What money came in, what went out, and what's available for distribution. That's the simplest way to think of an accounting. And the inventory I've created kind of creates a starting point from which you can measure all of that. And there's no particular deadline on when the accounting's due. It's just that it needs to be filed when we go to close the estate. And the estate, by statute, needs to be closed within 2 years. Now, when I work on those, we always try to get them done much sooner than then. But sometimes things happen and 2 years occurs. If it's a very high net worth estate, you've got a 706 federal estate tax return that needs to be filed. It might take that long, or if there's litigation from a wrongful death or something like that. 2 years comes by, the court might inquire by order saying, show cause why this estate is still open. And so we do a status report to the court on behalf of the personal representative, or the personal representative does, saying here's why. So those are the general things to keep in mind in terms of fiduciary duties and deadlines.
Thank you very much.
Excellent.
Mm-hmm.
Thank you.
Jon, I was thinking back to the point that you made about the accounting records. In our practice, we can see it done different ways. For a lot of mutual clients with your firm, we see your office keeping the accounting records. So you keep track of the checks written, the income coming in, and so you provide those accounting records. A lot of times PR keeps those records as well. So we've seen them done both ways, where personal representative can hire your firm, it can hire accounting firm, or they can do that function by themselves.
Right. You're exactly right. I think the
Yeah.
best thing to keep in mind is keep records right from the beginning. Don't go down the road and then try to recreate what we do here. Keep a ledger of what expenses, receipts, everything that's been going on.
Yeah. Jon, you've done a fantastic job talking about the things that personal representative need to get done right away within the first 4 months. Let's say this is a first-time PR, and they're kind of doing it by steps. They've got the things done that you listed here, and they're kind of wishing to themselves, I wish that I had the prior experience being PR, because I kind of don't know what I don't know. Like, I wish I knew what would be the best practices, what I should be avoiding, what I should be doing or not doing. Do you have a few suggestions for first-time PRs on what they should be doing and not doing?
Yeah. And we can go through that. I think that we can kind of list what they might be, but the thing would be off the top of my mind is do things in an open and transparent way. So you're not favoring one heir or devotee over another, where for whatever reason, maybe if it's a friend or it's a family member, you are a fiduciary. You're working not in your own right, in your own interest, but you're working on behalf of the estate for all of the heirs and devotees. So do not favor one over the other. You want to keep them reasonably informed of what's going on. Reasonably informed to me means that every so often you're giving them an update, even if it's unsolicited. Now, of course, if they ask for an update, sure, you want to timely respond to that. But otherwise, you are still giving them some sort of an update. Maybe it's through the family grapevine, maybe it's more formal, but it's always, remember talking about managing expectations. Should be doing that. You as personal representative, avoid conflicts of interest. So we're not wanting to commingle the estate funds into your own account. You want to have a separate bank account, for instance. If you are interested in acquiring an asset of the estate because it's something you want or need, well, you're the personal representative. You need to be thinking about that. You need to be probably either getting court approval, or you want to at least talk to the heirs and devotees and say, here's what I have in mind. Here's what I have for a price. Here's how I determined that. I got an appraisal on it. And if you don't have any objections, I'm going to buy that from the estate. So those are the type of, conflicts to avoid. Now, that being said, it's not out of the ordinary that the acting personal representative could also be an heir or devotee of the estate and has a share in the estate. That's to be expected. There's where, when you have the inventory and the accounting, all of that will take care of itself in terms of what's the fair share for anyone. But if you're talking about acquiring an asset, we need to make sure that we're taking that extra step. Okay. I think another thing would be work with the professionals, work with legal counsel to guide you through that. It may seem that acting on your own right as personal representative is something you can do. It's a gauntlet, and I think that you should at least seek the legal advice, if not the full assistance of that, not only of legal counsel but of other professionals, particularly your accountant, because this is the financial assets that we're doing in taking care of the decedent's estate. And then while doing all this, you're entitled to a reasonable fee as a personal representative. State law used to state until the 2019 legislature that you could take a reasonable fee up to a maximum amount, and that maximum amount was a formula created by statute. That's now been eliminated by the Montana legislature, and it's strictly just a reasonable fee, of course, with no definition of what that is. So my thought, or my recommendation would be, is keep records of everything you've done, keep records of your time, your activities, and could talk to legal counsel, the accountant, about what would be a reasonable rate for the time that's expended on that. That's a good way to think about it. And because an exorbitant fee will be challenged. I'll guarantee it will. There'll be litigation, and you might have some personal responsibility for that. No requirement to even take a fee at all, but you are entitled to reasonable fees. Remember, fees are taxable income to the personal representative and they need to be reported as such.
And it's interesting point that if there is one-time PR service, if the person is not a professional PR, they're doing it for their mom and dad for one time, the fees that they get as personal representatives are just subject to income tax. But if somebody does it as a business, where they are being PRs, commercially, where it's their business, then this income becomes subject to two taxes: income tax and self-employment tax. And Jon, I can see on your points here, you have some tax-related deadlines as a subject. And this is mine and Nicole area of expertise. We absolutely love working with clients on estate and trusts tax returns. And so I just wanted to share that I absolutely love to be involved in working in this field together with attorneys, with PRs, and work as a team.
Yeah.
Because we can all help each other and we can avoid higher taxes. We can avoid any delinquent filings. We can prevent penalties. And working as a team helps pave the road to the efficient work on this estate. So this just gets me super excited when we talk about tax
Me
returns.
too. And I would just comment that, it is truly a team, because for the most part, it's going to be rare when one office knows everything there is to know and do what to do about an estate. It's the collective effort and knowledge of that. And we've learned that with working with your office many times, that boy, it creates a better situation and a better result for our clients when we're working together in that respect. And I can go through what's that I had listed at the top of mind there. Of course, there's the decedent's final estate income tax return that's going to be due after let's see, that says 15.5 months after the end of the month prior to death. That's a lot. That's a mouthful. But just remember, we need to file that final income tax return. The estate has an income tax return as well to file. And that needs to be kept in mind as well. May not actually need to be filed, but there would be, a certain amount of income that may trigger that. So we need to keep that in mind. Right. If the estate or if the decedent was fortunate enough to accumulate wealth and had enough wealth that it would generate an estate tax, that needs to be filed, and you can see there that's due within 9 months, or unless there's an extension on that. And that reminds me of, related to that, is that a spouse under current rules, whatever if it's a husband and wife situation, say husband's passed away, whatever husband doesn't use on the estate tax exemption can be claimed by the spouse. And that's called portability. And so that spouse needs to formally claim that unused amount. And that deadline is the same as the estate tax return, because it's actually part of the estate tax return. Another thing to think about would be if the decedent happened to be a partner in a partnership, that there's the Section 754 election due with the partnership return. You can correct me if I'm wrong, but I'm thinking that would be for a special adjustment of basis as to the partners, the estate's interest in that partnership. Okay, and then there's the spousal trust elections. If it's a member of a subchapter S corporation and the shares are going into a trust, we need to make sure that that trust is an appropriate holder of subchapter S corporation shares of stock. So there's an election that needs to be done, and that deadline is 2.5 months after the transfer of the shares into the trust. And then there's the Q-tip election that needs to be taken care of as well. If we have a Q-tip trust, qualified terminal interest property, say it goes to a spouse, the spouse would have the ability to elect whether the estate, the assets in that trust will be deemed to be part of the surviving spouse's estate or the deceased spouse's estate for estate tax purposes going forward. So those are some things that come to mind. I don't know if I have quite the passion for those deadlines as you two do, but they're there.
We love them. We love them. It drives our days. It makes us feel happy when we file the returns, the estates get closed, and everything is done well in its own time, and there are taxes saved, and there is great teamwork with offices such as yourselves. It's great. So, Jon, I have a question for you. We've been talking about PR being a single PR, but once in a while we have a situation where there are multiple PRs. Do you ever have any stories about either success or failure of having multiple PRs running the process?
Yeah. Again, I would say, regardless of whether it's a single trustee or multiple trustees, by far, there's never any issues. By far, that's the case. But sometimes that does come into play, especially when you're thinking about a co-trustee or a co-person representative situation, because now they need to act together. They need to both be rowing the boat in the same direction. And I have been fortunate, and that's been the case that I've come across in virtually everyone, but there's always the whole spectrum you come across. And I have come across a situation where it was two sisters appointed as personal representatives of the estate, and it was a probate, and they just did not get along, and it was an element of distrust with each other. So no problem with the estate plan, no incapacity, no undue influence. That wasn't what set them off. It wasn't anything else, but it was their inability to have the relationship between the two of them. Unfortunately, there was an element of distrust that obviously predated the parent's death, and it was not a good matchup from an estate planning standpoint to put those two sisters, and there were other siblings, together to work together. They may have thought that would have been a check and balance, that this could against each other. Well, it turned out to be, in that particular instance, a total train wreck. They didn't even trust each other for one to go into the house, because the other one was thinking in her mind that the sister was stealing personal property out of the house. And so sometimes our best laid plans can still go awry, with that. But that's also probably could have been recognized, with some communication and discussion as well. They made no efforts to communicate. What ultimately happened in that? Well, more time, more expense. They ended up getting, I ended up being excused from that because I had jointly represented them. They each got their own counsel. So they went from my office's counsel to each having their own counsel. Things took a lot longer. Things were a lot more expensive. And so that is just a reminder that if we are going to act as a personal representative, that we consider whether that's what the situation is I'm getting into, what would make sense how to make the best out of, even if I feel that it may not be the best situation for me. I'm going to be dealing with someone that I really don't have a good level of trust with, but how can I make it work? And if it can't be worked out, maybe there's some other way to get it resolved. Maybe someone else acts, or one acts, the other doesn't. But that's a war story that fortunately it hasn't come up that often, but that certainly did. And I left that matter feeling very dissatisfied. And of course they did as well.
Yeah. Well, and hopefully in our experiences, we have some war stories that end up negatively, where it ends up with litigation. And there are some success stories as well that goes well, where everybody does everything right, and there is no litigation. Can you share a couple more war stories with us? Those are so fascinating for me because I learned quite a bit from them too.
I think, just the other side of the coin of the one I talked about, I had one that was very similar to that where, it was a family of four who they knew they couldn't get along. The estate plan had two of the brothers being named as personal representatives. And they originally, before anything was filed with the court, they were already kind of, at each other in the background. Each had hired their own counsel, but they had the wherewithal or, the sense to think about the overall good of the estate and what we're doing. And so what happened in that instance is that neither one of them acted. Contrast that to the dueling sisters that I just talked about, and brought in, upon agreement, a neutral, non-family member personal representative to handle the estate. And I represented that neutral personal representative. So in that instance, our personal representative was able to sit down with everyone, listen to what their concerns were going forward, did everything right, did everything on a timely basis, kept them informed, did the accounting, did the inventory, everything that needed to be done, they did. And he remained objective, he remained neutral, and remained patient and understanding. And what could have been certain litigation in that instance, because it was a multi-million-dollar estate with a lot at stake, turned out to be something that went pretty darn well because the personal representative acted in that manner. And I got to give credit to the heirs and devisees who recognized it wasn't a good situation for them to be taking care of that. Now, again, most of them don't have any issues like that at all, but here's a situation where it did arise, but there was a positive result to that. Okay.
I could see too, Jon, how sometimes someone who's appointed to be the personal representative would not feel like they have the skill set or the time available to really serve the role as it should be, and that you could benefit from finding someone who is able to fully serve the role.
Yeah. Whether it's a family member or a professional, worst case scenario, the Cascade County here in Great Falls, where I'm at, has a public administrator if there's just no one there to take on estates as a matter of last resort or for indigent families. But yeah, it's communication's always the key, and the ability to take on that and the desire to take it on.
Yeah.
And then in terms of another situation where it wasn't dueling co-person representatives and that, but it was, what I see typical in this area, because we've got an agricultural based economy here. We got a lot of farmers and ranchers. So it's not out of the question that, an estate could be comprised of, well, we've got the son or the daughter who's there on the property going to take over the operation. And there are, say, two other children that are off of the operation, and they're living, somewhere else, maybe even out of state. And the estate plan that is now into probate or trust administration is a product of mom and dad trying to figure all that out. And oftentimes it's a matter of, okay, we're going to give the land to the person who's taken that over because they need that land to eke out a living. Mm-hmm. So land rich, cash poor. If you're just looking at a balance sheet, then the value of what that child received may be substantially more than what the value that the other two received. And this actually happened in more than one of my situations. But what I'm thinking of is that, yeah, that was the case. And it turned out to be a positive thing because what happened? Everybody got together right at the beginning. I don't recall in this matter whether mom and dad actually expressed anything beforehand. That would be the starting point, and I'll talk about that in a moment. But the personal representative was actually, it was the son. It was the son who took over the operation and who got the disproportionate share of the estate, but did everything right, did everything in a compassionate manner, had the family meeting, explained what was going on, had the notes, had the explanation from what mom and dad wanted to do, why that would keep the, the operation going, why it was viable. And just having that communication, and then doing anything on a timely basis, not favoring himself or everyone else in terms of anything, not favoring anybody else in the estate over others, doing the inventory on a timely basis, doing the accounting, did all that. And what could have been a very sticky situation turned out to be, in the end, one that everybody was totally fine with and they were happy. Because what happens when, especially families are not, two business people can have a disagreement and maybe even go to litigation and they dissolve their partnership or whatever it might be, and they're on to their next business. They're driven by that. Family members, they get into that situation and it can be something they take with them to the end. And so we want to avoid that. Any way we can do that, we certainly try to do that. So that's why I'm sharing these stories as well.
Very good. You did mention some estates that have businesses inside them. And of course, those estates are a little bit more complex. And so would you have any tips for for people, not necessarily for personal representatives, but general ideas for people who are thinking about their estate planning, and maybe they do own a business? Is there something that they can do while they're alive that would help personal representative down the road?
Yeah, and I think it would apply, Lana, whether it's a business owner or not. And the main things is to have a plan in place. And it's whether it's a will-based plan or a trust-based plan, but you have it in place and you keep it up to date. Don't do your plan and then put it on a shelf and then 30 days later pass away and expect that plan's going to fit the needs of what's going on there. So have a plan, keep it up to date, but also have an organization, keep your records organized as well. So when you do pass away, folks know, your family knows what it is you have, how to access them, whether they're still in place. If it's an old insurance policy you stopped paying premiums on, throw it away. So we're not going down a rabbit hole on that. And because that oftentimes leads to dissatisfaction. You got one heir saying, where's the money from that insurance policy? Well, there wasn't an insurance policy, as it turns out. So all of that is things we can do before death that we can help down the road folks avoid. Keep my plan up to date, organize my records in a very precise manner, as precise as I can get, and communicating that to family as well. And then I've also, you see on the slide here, giving some special considerations to joint ownership or TOD or POD designations. I included that is to think that, well, that may in and of itself, if it's a more modest, simple estate, just avoid the probate altogether. If it's just a beneficiary designation, that's going to be a contract with the bank or the insurance company to pay a right to those beneficiaries. And as long as it is done in a fair way that everybody, that the decedent desired it should happen, that's going to be fine, joint ownership as well. The thing, though, the downside to be careful with on that is that if mom and dad just add, a child as a joint owner on the account because they see that as a convenient way to make sure the bills are paid when I'm incapacitated, or they've added them as a TOD designation or a POD, which is pay on death from a bank account to get the money and pay the bills. Yes, that may be you're trusting that individual to do that. And in most instances, that's probably exactly what that person will do. But just need to keep in mind, when they are a joint owner or a beneficiary and they receive that, technically and legally, they are the only owner, the legal owner of that. They have no legal obligation to share that with anyone. And putting them in that situation in a worst case scenario may actually lead to litigation because the others are now dissatisfied that that's what occurred and they're not willing to share that.
And on the tax side, what happens if the daughter, let's say, or a son are put down as joint owners, if that son or a daughter wants to share that wealth with the remaining beneficiaries, sometimes they come to this situation where they have to do gift tax returns because they're being kind, they're kind of being penalized for that kindness as well.
So the probate avoidance or the, that plan probably it created more work and more effort, maybe even more cost than what they realized they would. And there's ways to accomplish the same thing. Don't do it as joint tenancy or a TOD. Use the powers of attorney so they've got a power to act on your behalf, pay your bills and do all that, and other considerations that too much for today. But there's ways we can still accomplish that without creating more potential havoc down the road.
Mm-hmm. Very good. Very good. So, Jon, based on what Nicole and I heard today from you, I can make this assumption in my mind that if I was the first-time PR, and if I was asking this question of myself, how to avoid litigation, I can clearly see that the more pre-planning you do before even the decedent died, the more communications that are done, then the job gets done easier because PR knows that they're going to be future PRs. Then they know what their responsibilities are. And even before that happened, they can learn more. They kind of know what their duties are if that's communicated to them early on. But also for people who were not informed that they're future PRs, if they get a phone call and they're told, hey, you're named the personal representative in such and such a state, what I hear you say is that when this PR, personal representative, has a good team on his side, and the team of attorneys or team of CPAs, then the personal representative can lean upon the advice. And this advice coming from your office, from Scott, Tuckerud, and McCarty, for example, that advice can save them tens and sometimes $100,000s of possible litigation because they can reach out. You could be the sounding board to them, and you can work as a team, avoiding litigation, avoiding penalties, avoiding additional tax. We've really had really good experience working with your firm, working as a team, using each other as sounding boards and offering options to PR. For example, the timing of distributions. Sometimes you can write checks out of the estate on December 31 versus January 1, and it would save taxes. And it all takes planning. It all takes forethought. It all takes communications. And regardless where our PRs are in the process, we invite them to find people who they trust, that they can come and talk to them.
Well, I agree. Everything. I guess, to say that in a word or two is that they're not alone. They're not on an island. We are here. Your office and my office, professionals are here to help guide them through that process.
And professionals who have experience dealing with this particular area, because it is something that is special and unique. And so it is nice to have the supportive experience.
Agreed.
All right.
Nicole, thank you very much. Jon, I loved hearing your stories. Thank you for the time. And if any potential PR has any questions, feel free to contact us anytime. We would be happy to talk to you. Yes. Have a great day, everybody.
Thank you, Jon.
Thank you.